Good morning, everybody. I know I can't get a response because Chris has muted you all, but it's nice to see you all again after a year, and very unusual year. And in this unusual period, I often get I've had quite a few strange questions. I was recently asked by a client to prepare a lasting power of eternity. I said to the gentleman, well, I've been practicing law for about 40 years, but I've never come across legislation that can guarantee living forever. The widening wealth gap between generations means, in my view, that we're living in what has been termed an inheritance society. Wages are not keeping up with prices, and as I'm sure many of you know from personal experience, that you may have grandchildren who cannot afford a home that they can call their own. And wealth now, it comes from inheritance and not work. We're living longer. Parents are dying in their 90s, and making gifts to children and grandchildren can sometimes be too little and often too late. But there's always a desire for parents to want to provide for next generation. So the question is, how do you strike a balance between ensuring that your twilight years are safe and secure, whilst helping the next generation or two to get a start in life now, rather than when it tends to be too late? I'm often asked by parents whether or not it's a good idea to put the family home into a trust. And I always give the typical lawyer's answer: possibly, or maybe. Not because every case is different, but having to spend time to consider the client's particular circumstances allows me to charge a handsome fee and which helps to cover the cost of mooring my multi-million-pound yacht off the coast of Monaco. You may have seen it. It was a large one. You may have seen it last Sunday at the Grand Prix. It was a large one just at the third bend, but not really, if only. Now, when are trusts useful? That's something I'm always asked. Well, trusts are useful, particularly when you want to protect the vulnerable. You may have a child with special needs. Avoiding inheritance tax. That's something that is perfectly lawful. And a person who wants to gift their home to a child has an allowance of £500,000. So a couple who decide to gift their estate to each other and then to the children on second death will have a combined allowance of £1 million. Now that you think may sound very generous until you consider what many financial observers say will be a predicted surge in house prices over the next several years, caused by the Treasury pumping billions of pounds into the economy to shore it up over the last year. And you can bet your bottom dollar that the Treasury is not going to keep allow allowances to rise, because they want to claw back as much as they can from the taxpayer to pay off the massive debt that generations to come will have to pay. But is it ever wise to put the family home into a trust? My view is that putting the family home into a trust is unlikely to avoid inheritance tax, because if you continue to live in it without paying the market rent to the trustees, the revenue will say that the transfer never in fact took place, because you effectively made a gift whilst reserving the benefit to yourself. In that situation, unless you were to pay the market rent, the home will always be considered yours for the purposes of calculating tax. Not only that, if you were to transfer a property into your home into the name of your children, who can decide when it's sold? It's certainly not you. What if a trustee, a child, were to get divorced or have money problems? A spouse in divorce proceedings could claim a share in the home. A child with debt problems may put you under pressure to sell the home so that they could free up capital or cash to pay off their debts. Some people say, well, I trust my son and daughter to do the right thing. Yes, you may do, but to what extent do you trust your child's partner? That's a moot point. So I often advise people that placing a family home into a trust is something that should only be considered by the very wealthy. And my advice is to err on the side of caution. But what about trusts and avoiding care fees? In my view, the issue of care fees are more likely to reduce the value of the estate than, say, the effect of inheritance tax. Although most people do not go into a home, those that do, particularly in the southeast of England, are likely to spend about £80,000 to £100,000 a year in care fees. And unless your spouse or partner or child aged 60 or over remains in the home whilst you are in care, the house can be used to cover the cost. If you're going to take steps to shelter assets from paying to care, such as placing a home in the name of another person or trust, say, you may be found guilty of deliberate deprivation of assets, which is, of course, unlawful. So certain care must be taken if you were to consider that option. But however, there are many situations I've come across when placing an asset in the name of others will not fall foul of the deliberate deprivation rules that apply when assessing care. It often boils down to what was intended when the property was transferred. Now, I advised a few years ago a client who lived with her mother for most of her life, although the house was in her mother's sole name. My client found a teaching job in the north of England, and she moved out and moved into rented accommodation. And at that time, they decided to put the home into their joint names, into the name of mother and daughter. Subsequently, when mum went into care and daughter was still in the north of England, social services says, well, the house should be sold because it's in mum's sole name. And in any event, it was transferred into joint names to deliberately deprive the mother of an asset to pay for care. However, I was able to argue successfully that the decision at the time to put the house into joint names was not done deliberately to avoid assets available to pay for care, but was in order to secure a home for the daughter one day. She was raised in the house, that's the daughter. She moved to the north of England to secure a teaching job, and she was living in rented accommodation. So it boiled down to intention. What was the intention of the parties at the time of the transfer? And the local authority backed away. Now, another situation where there is nothing wrong in gifting assets to friends and family, children and grandchildren, is when you want to make lifetime gifts to avoid inheritance tax, which is perfectly lawful. We all know that gifts of up to £3,000 a year is exempt from tax, and larger gifts will fall out of this state if you survive for 7 years, I hear you shout. So if you have savings or investments earning little or no interest, and you don't believe you need to rely on in the future, why not consider gifting them to your children to avoid tax? Because another effect or cause result will be that you may have fewer assets which can be taken to pay for your care fees. I spoke not so long ago to a client who said to me that her granddaughter wanted to buy her first home, but was unable to get the size mortgage she needed. And my client had about £100,000 sitting in Santander account, doing absolutely next to nothing. And she wondered if there would be any problems if she were to gift that sum to her grandchild. Well, I said, well, not only would that gift fall out of her estate after 7 years, and therefore £40,000 of that gift would go to the family and not to the Chancellor of Exchequer, but also I didn't think it would be that the decision to make the gift would be questioned. Well, not long ago, my client had a bad fall at home. She broke her hip, and it was decided by the family and her that she couldn't receive the care she needed within her home, and she went into care. And social services said, well, what about that £100,000 that conveniently left your account just before the fall? We want that back, thank you very much. But I was able to, I wrote a long letter to Enfield stating, well, if you were to look and examine the situation, the gift was made to the grandchild's conveyancing solicitor just before she purchased the flat. And you are not saying that my client deliberately fell down the stairs to and break her hip in order to avoid paying for care. Well, that letter was written to Enfield a few months ago, and so far I'm still waiting for an answer. Now, I'm often asked if there's other things that can be done to protect family assets. And I frequently advise couples about gifting their share in jointly held property to children by way of property protection trust wills. Most commonly, couples make wills gifting their estates to each other and then to the children on second death. In such a scenario, if the survivor needed care, the entire value of the house would be used to cover the cost of care, leaving little or nothing to the children and grandchildren when the survivor died. Where a property protection trust will is concerned, trusts are created on first death, and the trusts say that the survivor has a right to live in the property for as long as they like, so that on second death, the entire property passes to the next generation, whereas on first death, half the share in the family home belonging to the first owner to die is placed in trust for the children and not available to be used by the survivor for their care. But isn't that deliberate deprivation of assets to pay for care? I'm sure I hear some of you say or think. Well, no, because the assets of the person, the assets belonging to the person needing care are those assets that are means tested. And what they never had can never be assessed, because the asset, the share of the property, that belonged to the first spouse to die was transferred in a trust to the children. So effectively, you're ring-fenced half the value of the family home against being used to pay for the care of the surviving spouse. So that, I think, is a lawful way of mitigating the effect of care fees. And that is a way in which you can preserve your assets for your children and your children's children, if that is something that you want to do, which I think is perfectly laudable. Now, what about lasting powers of attorney? I think that the need for lasting powers of attorney is increasingly important in this digital age, particularly in the pandemic, when you've got a high incidence of cybercrime, of fraudsters who will call you up and say to you that there's been unusual movements in your account. If you just simply hand over your bank account details, it might be resolved. And not only that, in the pandemic, who wants to stand outside Barclays Bank in the chilly wind and rain that we're having in May, when in fact you could be in the comfort of your own home whilst you're arranging for leaving it to someone else you know and trust to manage your affairs? You don't need to engage a solicitor to prepare LPAs when they are available to download and complete. And that must be surprising, hearing that from a solicitor. However, there are occasions when it would be prudent to engage a professional. For example, on many occasions, I'm asked by families to prepare lasting powers of attorney for an elderly parent and donor who's becoming forgetful and has been diagnosed with early stage dementia. Here, time is of the essence to get the lasting power of attorney completed accurately and registered at the Office of Public Guardian before the health of the donor deteriorates to such an extent it is no longer possible for them to prepare such a legal instrument, where the only recourse is to take the expensive route of applying to the court of protection for deputyship. If a solicitor or other profession were to assist in preparing a lasting power of attorney, it would be harder for that document to be challenged. I advised a mother recently who prepared a homemade lasting power of attorney. Now, she was fully compos mentis, as they said, but she had 2 children that never got on from the day that they had to share a pram. They were twins, a son and a daughter. And it was her mother's wish that to appoint the daughter as a sole attorney. She didn't have full confidence in her son because he was a bit of a womanizer and he loved putting a bet on the horses all too often. And to the annoyance of her son, she appointed her daughter as a sole attorney, and she got her next door neighbor to certify that she had mental capacity. Now, when she applied to the Office of the Public Guardian to register lasting power of attorney, the son challenged the registration, saying that his mother lacked capacity, and secondly, he was being pressured by her sister, he said that his mother was being pressured by his sister to appoint her as a sole attorney. The Office of the Public Guardian was thinking about referring the matter to a judge for a decision. I advised the mother. Mother came to me saying, "What do I do?" My reason for excluding her reason for excluding the son was genuine. She didn't think that he and her daughter would get on, and she didn't trust her son. So I advised the mother, my client, to withdraw the homemade will, homemade lasting power of attorney, and start again. And I arranged for a mental capacity assessor to examine my client and certify that she had capacity. I also took measures to ensure that instructions were taken without the presence of the daughter to avoid the son claiming that his sister was exerting undue influence. And so when the second lasting power of attorney was filed, and after the son complained and challenged it again, it went to the judge, who decided that it was a perfectly lawful document, and he authorized registration. And so it's always, there are always circumstances where you should get considered legal advice to decide about lasting powers of attorney. Now, how has rulemaking changed since the start of the pandemic? Well, I've found that there has been a large update in inquiries for making wills, and I think it remains important now, as before, to take professional advice about how to draft your wishes, especially when your estate is complex. You wish to ensure that the way the will is drawn up avoids inheritance tax, as the maximum inheritance tax allowance makes use of the inheritance tax allowances available, and especially when there are tensions within the family and you want to balance making an equal division amongst the children, whilst at the same time recognizing one child's need may be greater than others. There may be one child who has received a fair bit during their lifetime. A substantial deposit was given to them when they bought their first home. And there may be another child who was always there for the parents during their twilight years, looking after them, attending to their care, and may be less fortunate than others financially. But you don't want the children to fall out when it's discovered that there's been an unequal division of the net estate. There it would be wise to draw up an expression of wishes, giving an historical account of how you've provided for the children during your lifetime and how they've provided the care. And so that in a way you're speaking from your grave, and it makes it less likely that the will be challenged. Now, I've said a lot, and I need to draw breath to have a glass of water. And whilst I do, does anyone have any questions to ask me? No. Does that mean you've all fallen asleep? Joan and Glenn, what question do you have?
Well, a long time ago, we put our house ownership as changed it to tenants in common, I think it's called.
Yes.
And did a will rather as you described, you know, on the first death, that person's half goes in trust, etc.
Yes.
We're now thinking of keeping the tenants in common.
Yes.
But changing our wills to simply leave everything to the other one.
Yes.
For simplification as much as anything.
Yes.
And it seems to me if you do that, then in any event, say the first one goes into care.
Yes.
Only their half of the house could be used anyway to pay for that long-term care.
Yes. There are two parts to that point you make, Jen. You place a jointly held property. You can hold a jointly held property either as joint tenants or tenants in common. If you hold it as joint tenants, on the death of the first co-owner, their share passes to the survivor, notwithstanding what is said in the will. It passes automatically. Whether if you hold it as tenants in common, the share of the first co-owner to die passes in accordance with their will, or if they haven't made a will under the rules of intestacy. And so if you were to hold it as tenants in common, you can still say, Jen, in your will, I want my share to pass to the co-owner, the surviving co-owner, or not. Or you could say it will pass to your children. It doesn't make much of a difference as regards to care fees are concerned, because if the surviving spouse remains in the home, then the share that you've left, the share cannot be used to cover the cost of your care whilst you are alive. If it passes to your spouse, who is the other co-owner, after you die, that share that you passed to your spouse could be used for their care fees. Do you see? And so potentially the damaging effect is that the entire value of your home, which is your main asset for most of us, can be whittled away, paying for the cost of the care of the survivor. Mm-hmm. And that's why some people would like to consider placing their share of the home in a trust when they die, gifting that share to the children, but on the condition that the survivor can remain in the house for the rest of their days. So that if the survivor goes into care, their share of the first co-owner, isn't available to pay for care. That asset doesn't pass to the survivor, and you can only be assessed on the assets that you have. Do you see?
Yes, but if you at the first death, that portion goes into trust. Yes. And then eventually at the second death, even if no one's gone into care.
Yes, yes.
Aren't there questions of capital gains?
No, because it's the family home. Capital gains tax does not arise on the family home.
But the children aren't living in that house.
No, but it doesn't matter. It's still the family home. The estate is not charged for capital gains tax on the family home, or indeed on any part of the estate on death.
Oh no, wait a minute. The half of it is owned, or it's owned by a trust, isn't it? Actually, as opposed to individuals.
Yeah, capital gains tax doesn't arise on second death. On second death, the survivor, it's treated as if the survivor owned, as far as revenue is concerned, the survivor owns the entire property and it's taxed accordingly. So if you were to set up a property protection trust and gift the share of the first spouse to die into a trust, as far as the revenue is concerned, the survivor still owns the whole of the house and is taxed accordingly. Remember, so if the estate, the total value of the estate is below 1 million, there is no inheritance tax to pay. And there's no capital gains tax to pay because there's an uplift. So capital gains tax is not an issue.
Would the trust itself not have any potential tax liability?
No, because the trust on the house is not sold until the survivor dies or decides to sell. And so the revenue will treat the house as belonging to the survivor for inheritance tax. Okay. And there's no capital gains tax to pay because on death, there's an uplift in the value of the house for capital gains tax purposes. So the only liability that arises is inheritance tax. And if the combined estate is below 1 million, there's no tax to pay. If the estate is above 1 million, tax is paid at 40% on that amount above 1 million. Mm. But in the situation that you described, Jen, it's perfectly fine for you to review your will, do your will, gifting the estate to each other and to the children on second death. If either of your husband were to go into care and leaving this other person in their home, then the house cannot be, the share of the house belonging to the person going into care cannot be assessed and used to cover the cost of care. Or if you have a child age 60 or over living there, it cannot be assessed.
Right, okay. Thank you. I think what bothers me most is that our old will from, I don't know, 25, 30 years ago reads to me like gobbledygook now.
Well, that's right, because we lawyers like to charge as much as we can. No, it's true. I mean, lawyers like to be wordy and long-winded because years ago, solicitors used to charge by the word. And so a typical will say, I give, devise, and bequeath. We all know what gives means, but what does devise mean? Give. What does bequeath mean? Give. Last will and testament. What is a testament? It's a will. But if you can, why charge £1 when you can charge £3? No, but wills tend to be wordy needlessly, and it's always good to review your wills at regular intervals, even if it's for you to get the advice that well, you don't need to change it. Your wishes will still be fulfilled, notwithstanding the will is a bit long-winded. Anyone else have a question?
Thank you.
Pleasure. No?
Well, if nobody has any more questions, it merely remains to say thank you very much indeed.
Sorry, John, can I ask a question?
Yes, please do.
In fact, I have a will which you made, Michael, at Stennett of Stennet about 8 years ago, and I'm starting to think about looking back at it. I have no direct children of my own, and so leaving things to sort of, to one niece and a nephew and so on. But it does, I think, thank you very much for the talk today, because I think it does actually make you sort of think, to try and anticipate what might lie ahead in your own life.
Yes.
Because if you do need, for example, care and so on, then having a discussion with family, having been advised by yourselves, what to do in particular circumstances. I'm not sure many of us actually think ahead like that, because it seems a bit...
Well, we should. I mean, I have two types of clients, those that plan and others that don't. Those that plan will pay, I call my bread and butter clients. They help me pay the rent, staff salaries. Those that don't plan allow me to cover the cost of my expensive fleet of cars. So, and that's very true. It's very true. It's always a good idea to review your affairs regularly, even if it's just to say, well, nothing needs to be changed. Always keep an eye on legislation. I mean, at somewhere or other, I think the government are going to have to try and claw back the billions that's been spent recently. They are going to be looking to everybody, including older people with assets. I don't expect inheritance tax allowances to increase. What I do expect, there's going to be a surge in house prices as a result of quantitative easing. What happened in the financial crisis in 2008 is happening now, but people are being distracted by COVID and the virus and the various injections that we're having. But I think in the next 2 or 3 years, we are going to see ways, both clearly and I think overtly, ways that the government is going to claw back money. It will do, and they're going to be looking at wealth. I predict that, and so if there are ways in which, if you want to help your relatives and friends and loved ones, you should consider doing it now, because all too often thankfully we are living longer, and hopefully that we'll live healthily. It's not about living long, it's living healthily. And if we can do that, fine. But remember that when you die at the age of 100, your children are in their 70s and 80s. They no longer need it, and it's often their children, your grandchildren, need help. And if you can help them now, why not do so? Why not do so?
Yeah.
But you need to do it in such a way that makes sense. If you're going to make a large gift to a child or grandchild in need, document it, explain why. Look at changing your will. If you've made a will saying I give to every child in equal shares, but you've given a lot to one child and not to another, and there is a particular child who hasn't got that place of their own, you need to consider changing the will, but do explain why you did it, because children will never accept that one child is better off than another. And you don't want rifts in the family. You don't want to have to be turning in your grave because they're fighting over the family silver.
Yeah.
So do come and see us. Now our offices has reopened. We're still practicing social distancing, wearing masks. But if you have any questions, please don't hesitate to call. You have my number, but I'll give it to you again. 0208 920 3190. You can email us, or you can visit our website. Our office is still at in Winchburn Hill Road, opposite Marks and Spencer. You can park across the road. I don't think the ticket machine, car park machines work at the moment, but if and when it is, if you pay £1 and buy a bread in Marks and Spencer, you get your £1 back and pop in and see us. But it'll be prudent to call first and make an appointment and come see myself or my able colleagues Debbie and Rebecca. They're able to. And Debbie, wave to everyone, Debbie.
Hello.
Rebecca's online, but she hasn't done her hair, so we can't see at the moment.
Hi everyone, hello. Hello.
Rebecca's still in her gym jams.
No, I'm not, Michael. But yeah, my hair hasn't been done, so yeah.
Okay. So I've got two very able colleagues who the three of us can advise you, not just about wills, powers of attorney, probate, but we have a very successful conveyancing department, and we're also estate agents as well. So if you want a free valuation of your home, happy to give it. All we ask for in return is a nice cup of tea. Okay.
Not even a glass of wine then.
Oh no, it's too early. After 5 o'clock, I'll break out. I'll break out the wine and the beer, but before then, no.
Thank you very much,
Thank you.
Michael.
Thank you. Well, you've been a lovely audience.
Are there any more late
Any more questions? Hurry up, I'm not charging.
Sorry, but enduring power of attorney.
Yes, Jen.
That's what we have from before they brought in LPA.
Yes,
We've looked online at LPA.
yes.
Two things. I couldn't really see any advantage apart from it's sort of pre-registered in a sense.
Yes,
The LPA, that is.
yes.
But also a bit I read, it seemed to say you couldn't change it, which really didn't make sense to me.
Are you talking about the LPA or the
LPA,
EPA?
yes.
LPA. Yes, once you've registered a lasting power of attorney, it cannot be changed.
Oh,
No, that's similar to an enduring power of attorney. That's why it's important that you get it right first time. Think carefully about who you want your attorneys to be and how they will act together, either together only or together and separately, or jointly and severally, as they used to say. I often say to clients, well, perhaps you'd want all your children or two or more of your children to be your attorneys in case one attorney were to emigrate or whose circumstances may change. But once you've made a lasting power of attorney, you can't change it. And enduring powers of attorney, if you have an enduring power of attorney, that's fine. You don't have to make a lasting power of attorney. But remember, enduring power of attorneys only relate to finances. They don't allow someone else to manage decisions regarding your health.
That's a different type of LPA, isn't it?
Yes, there are two types of lasting powers of attorney. One is for finance, to manage your financial, to make financial decisions for you, opening and closing accounts and shifting money, selling property. The other is for health, what medication you have, what medical treatment you need, what end-of-life decisions can be made on your behalf when you are no longer in a position to express your wishes. Whereas enduring powers of attorney are limited to finance only.
Michael, sorry, Michael, but supposing you have an argument with one of your people on your lasting power of attorney and you fall out with them.
Yes.
It seems a bit odd that you can't then,
Well, that's true. That's true. I think the reasoning being that you can't just write a letter to your bank or the office of the public guardian or to the attorneys to say, well, look, you're fired, because if you fire one, then you fire the other, because the attorneys are drawn up so that people can act together and independent. In those instances, what I would suggest you do is you consider making new ones. So you need to choose carefully. I would advise that where possible, you have more than one attorney. You may have a situation where you own a property jointly with another person, and and you have just one attorney acting for both of you, and you may want to sell that property. That other person may not want the property sold, or they may be sick or abroad. That's when you can appoint the other person as the attorney. So I always think it's a good idea to have more than one attorney.
So I'm still a bit confused, because you spoke about a lady who for some reason, the son and the daughter didn't get it.
Yes, that's right.
And I had the impression that you did the LPA again after she had done hers.
Yes.
And so you did a new LPA.
Yes.
So you revoked the other one, but she had to pay again.
No, right. What happened there? It wasn't registered, so didn't proceed. But there, the mother had two children, and she relied on one more than the other. She trusted her daughter to look after affairs, but her son, although she loved him dearly, and the mother loved both children equal measure, her son loved running after women. He only visited when he was a short of a bob or two, which was in fact, it was the mother's wish that her daughter be the only person that could manage her affairs and have access to her savings and investments. She didn't want to go through the expense of employing a professional to prepare the lasting power of attorney, and she downloaded a lasting power of attorney from the internet, and she asked the next door neighbor who had known the client for many years to certify that she had capacity. Now, when the son got wind of the mother's intention to register the lasting power of attorney, he objected.
All right.
He said no, two reasons. A, the mum has got dementia, which wasn't true. And secondly, that she was put under pressure by the daughter, his sister. And so I advised the client to withdraw that homemade lasting power of attorney and have one done by me on her behalf, because then I arrange for a mental capacity assessor, which is a doctor whose job it is, they just go around preparing reports and certifying people have mental capacity, to say that she's as right as rain. And also I excluded the daughter from all discussions I had with the mother and in the preparation of the lasting power of attorney. And so when it was, the second document was filed, an application was made to the Office of the Public Guardian for registration. The son objected again, but I was able to say to the court, no, well, look, here are my contemporaneous notes. Here's a report from a mental capacity assessor. This document is perfectly lawful. And the Office of the Public Guardian said, we're fine, we're happy to have it registered. And it was registered.
And now she can't, if she were to change her mind, she can't go back and say, oh, I'll have the son instead. She can't.
No, she'd have to do a new one. But I doubt very much she'd have the son instead, because I saw him recently the other day driving down the road in an expensive Ferrari. So I don't think he hasn't changed. There was a blonde in next to him, so he hasn't changed.
On that very happy note, we hope. Any final last questions? In that case,
No,
thank you.
can I just say, I think it's been really fascinating. Thank you, and I shall come and see you soon. Anyway,
Thank you. I look forward to seeing you, Jean.
But I think the one of the things I did hear some time ago is, of course, when the National Health Service was set up in 1948, we lived about 20 years less than we do now.
Yes.
And I think it's going to get more and more complicated, isn't it, as families sort of, perhaps get parted and so on. And I think it's been very helpful. Thank you very much.
Thank you very much, Jean.
Thank you.
It's nice to see a few people. I'm recognizing those who I see on the screen. I recognize a few faces. Barbara, nice to see you. Waving. Okay. All right. Thank you all.
If anybody missed Michael's contact details, they are all on page 10 of this latest newsletter. So
that's right.
All you do, turn up your newsletter, page 10, and off you go.
That's right. Or visit us on the website. Just search Stennet Solicitors.
John, is the newsletter on file? I don't think I've actually received a paper copy of the newsletter. Is it on the website?
Yes.
Okay, thank you. You don't cut hair by any chance, do you, Michael?
No, do you?
No, I could do with it.
Oh dear, I was looking a wreck over. Well, I think while I was looking a wreck over the pandemic, but my wife swore blind. I don't need a haircut. That means she doesn't look at me. Whereas when she gets her hair done, if I don't spot it the moment she steps through the door, I won't have any dinner for a whole week. All right. Thank you very much.
Thank you.
Thank you very much. Thank you.
Bye.
Bye-bye.
Bye-bye.
Bye.